Module 1. Crime in America. Criminal justice and the crime picture. Criminal justice refers to the system of laws, institutions, and practices established by a society to maintain social order, deter criminal behavior, and administer justice to those who violate the law. It is a multifaceted field encompassing various elements, including law enforcement, courts, and corrections. The criminal justice system seeks to achieve a balance between punishment and rehabilitation. It aims to hold individuals accountable for their actions while offering opportunities for rehabilitation and reintegration into society. The principles of due process, fairness, equality, and the protection of individual rights guide it. Components of the criminal justice system. The first component of the criminal justice system is law enforcement. Law enforcement agencies, such as the police, are responsible for preventing and investigating crimes, apprehending suspects, and maintaining public order. They maintain a crucial role in gathering evidence, interviewing witnesses, and building cases against people accused of committing crimes. Law enforcement refers to the collective efforts and activities by governmental organizations and agencies to maintain law, order, and public safety within a jurisdiction. Law enforcement agencies enforce laws, prevent and investigate crimes, apprehend offenders, and maintain societal peace and security. Other facts about law enforcement include: in law enforcement, the majority of employees have general arrest powers. State police agencies employ the least number of officers nationwide. Most police officers in the United States work for a local agency rather than a state or federal agency. And less than half of the population occasionally interacts with the criminal justice system. The second component of the criminal justice system is the courts. Once law enforcement agencies make an arrest, the case is brought before a court of law. The court system is responsible for determining the guilt or innocence of accused individuals. This process involves presenting evidence, examining witnesses, and legal arguments from the prosecutor and defense. The court's primary objective is to ensure fair and impartial trials and deliver appropriate judgments or sentences. The third component of the criminal justice system is corrections. Corrections encompasses various institutions and practices to rehabilitate offenders and provide punishment or rehabilitation for their actions. These include prisons, probation, parole, and community-based correctional programs. Corrections aim to protect society from dangerous individuals, deter future criminal behavior, and facilitate the reintegration of offenders into society. Investigations. Police investigations are the systematic process through which law enforcement agencies gather evidence and information to identify and apprehend individuals involved in criminal activities. These investigations aim to uncover the truth, establish facts, and build a case against potential offenders. Law enforcement officers use many tools when investigate crimes. One of those tools is CopLink, a real-time data integration system that enables law enforcement agencies to access and share information from various jurisdictions. It's designed to assist detectives and investigators by providing a centralized database of relevant information. CopLink allows for the efficient search and retrieval of data related to criminal activities, suspects, vehicles, incidents, and other pertinent details. CopLink aims to enhance collaboration and information sharing among law enforcement agencies by integrating information from different sources, ultimately aiding in resolving investigations. Crime. A crime is an act or omission that violates a law established by a governing authority and is punishable by that authority. Crimes are typically classified into different categories based on severity, such as misdemeanors, which are less serious offenses, and felonies, which are more serious offenses. A person commits a crime for a reason or rationale. The rationale behind a crime refers to the underlying reasons or motivations that drive the individual to engage in the illegal activities. It involves understanding the factors and circumstances that contribute to someone's decision to commit a crime. The motives behind criminal behavior vary widely and are influenced by individual, social, economic, and psychological factors. Is crime rational? The idea that crime is rational is based on the understanding that people weigh the costs and benefits before engaging in criminal behavior. According to rational choice theory, individuals make decisions based on rational assessments of their actions' potential risks and rewards. In the context of crime, this theory suggests that people engage in illegal activities when they believe that the benefits of committing the crime outweigh the potential costs. The concept that crime is rational provides insights into the decision-making process of offenders, but it does not, of course, excuse or justify criminal behavior. Rather, it serves as a framework for understanding and addressing the factors contributing to criminal activity and guides strategies for crime prevention, law enforcement, and the criminal justice system. Key elements of the concept that crime is rational include 1. Cost-benefit analysis. People considering committing criminal behavior weigh the benefits that they can gain from the crime against the potential risks of the consequences. Benefits may include financial gain, personal satisfaction, or achieving a desired outcome, while risks involve legal penalties, damage to reputation, and harm to others. 2. Opportunity and perceived rewards. Rational criminals are more likely to engage in criminal activities if they perceive a favorable opportunity for success and believe that the potential rewards outweigh the potential risks. For example, someone may commit burglary if they see an unsecured target with valuable items and believe that they can get away with it. 3. Deterrence and crime prevention. The rational choice perspective also suggests that enhancing the perceived risks or decreasing the expected benefits of crime can deter potential offenders. Effective deterrence measures can include swift and sure punishment, increased surveillance, improved security measures, and educational campaigns emphasizing the negative consequences of criminal behavior. Crime prevention is the attempt to reduce and deter crimes and criminals. Situational crime prevention is a crime prevention strategy that focuses on reducing opportunities for crime. It's based on the idea that crime is often opportunistic, and that by making it more difficult for criminals to commit crimes, we can reduce the overall crime rate. For example, crime is reduced in situational crime prevention if motivated offenders are denied access to suitable criminal targets. Deterrence, on the other hand, is a crime prevention strategy that relies on the threat of punishment to discourage people from committing crimes. There are two main types of deterrence: specific deterrence and general deterrence. Specific deterrence is preventing crime by punishing the individual who committed the crime. Specific deterrence aims to convince the individual that the punishment is not worth the risk of committing the crime again. In other words, specific deterrence suggests that punishment should be severe enough to convince convicted offenders never to repeat their criminal activity. General deterrence prevents crime by punishing criminals to discourage others from committing crimes. General deterrence aims to create a climate of fear and apprehension amongst potential criminals, making them less likely to commit crimes. In other words, general deterrence assumes that sentencing a person to life in prison for murder will serve as an example to other people. 4. Rationality in context. It's important to note that the rational choice perspective does not imply that all criminals are highly calculating and deliberate in their decision-making. Factors such as impulsivity, emotional state, situational pressures, and social influences can also play a role in criminal behavior. Additionally, rationality in crime may vary depending on the individual's socioeconomic status, education, and other personal circumstances. Search for causes of crime. Age and crime. The relationship between age and crime is one of the most well-established findings in criminology. It is known as the age crime curve, showing that crime rates tend to increase in adolescence, peak in the early 20s, and then decline throughout adulthood. Several theories attempt to explain the age crime curve. One theory is that adolescence is a time of heightened risk-taking and impulsiveness, which can lead to criminal behavior. Another theory is that young people are more likely to be exposed to crime-heavy factors like poverty, poor parenting, and peer pressure. The age crime curve is not universal, as there is some variation in the shape of the curve across different countries, cultures, and historical periods. However, the general trend of increasing crime rates in adolescence and declining crime rates throughout adulthood is consistent across many studies. The age crime curve has many implications for crime prevention and intervention. Key points about the relationship between age and crime include: 1. Juvenile delinquency is criminal behavior committed by individuals below the age of majority, which is usually 18. Juvenile crime rates are often higher than other age groups, with offenses such as vandalism, theft, drug-related crimes, and violent acts being more prevalent. However, it's essential to note that most juveniles do not engage in criminal behavior. 2. The age crime curve peaks during late adolescence and the early 20s, with individuals between 15 and 25 years old most likely to engage in criminal activity. This age group is more prone to impulsivity, peer influence, and exploration of personal boundaries, which contribute to increased risk-taking and involvement in criminal acts. 3. Crime rates tend to decline as individuals progress into their late 20s and beyond. This decline can be attributed to various factors, including increased maturity, excellent social stability, muscular attachments to conventional societies such as education, employment, and family, and a decreased likelihood of engaging in risky behaviors. Several factors contribute to the relationship between age and crime. Biological factors. Biological changes during adolescence, such as brain development, hormonal influence, and the onset of puberty, may contribute to increased impulsivity and risk-taking behaviors. For example, genetic makeup also determines the likelihood of criminal behavior. Social and environmental factors. Peer influence, family dynamics, socioeconomic status, educational opportunities, and neighborhood characteristics can influence a person's likelihood of criminal behavior. For example, elderly males are predominantly arrested for alcohol-related matters, such as public drunkenness or drunk driving. Life transitions. Life events, such as getting married, starting a family, or entering the workforce, often coincide with a decreased involvement of criminal activity, as individuals take on adult roles and responsibilities. And finally, individual differences. While the age crime curve provides a general trend, it's essential to recognize that not everyone follows this pattern. Some individuals may continue to engage in criminal behavior throughout their lives, while others may never commit a crime. Individual characteristics such as personality traits, self-control, and exposure to risk factors can influence a person's propensity for criminal activity at different ages. Negligence. Negligence is the failure to exercise reasonable care when such care is required. Criminal negligence is a more severe form of negligence that involves a gross deviation from the standard of care of a reasonable person. Negligence can be a factor in several crimes, including criminal negligence causing death. This is a crime when someone's negligence results in the death of another person. For example, a driver who's negligent and causes a fatal car crash could be charged with criminal negligence causing death. Criminal negligence causing bodily harm. This crime is committed when someone's negligence results in serious bodily harm to another person. For example, a doctor who's negligent and causes a patient to become paralyzed could be charged with criminal negligence causing bodily harm. And also reckless endangerment. This crime is committed when someone's reckless behavior creates a substantial risk of severe bodily harm to another person. For example, a person who fires a gun in the air in a crowded area could be charged with reckless endangerment. The relationship between negligence and crime is complex. In some cases, negligence may be a necessary element of a crime, such as criminal negligence causing death. In other cases, negligence may be a factor that contributes a crime, but is not an essential element of the crime. For example, a person who's negligent and causes a car accident may not be charged with a crime if the other driver was also negligent. The distinction between negligence and crime can be challenging to draw. In some cases, it may be a matter of opinion whether someone's behavior was negligent or criminal. However, the law provides some guidance on this issue. For example, the law may define negligence as failing to exercise the care a reasonable person would exercise in the same situation. This definition helps distinguish between less serious negligence, which may be a tort but not necessarily a crime, and negligence that rises to the level of criminal activity, as it provides a standard of care that can be used to assess whether someone's behavior was merely negligent or criminally negligent. In general, keep in mind the following. Negligence is considered less severe than recklessness. In instances of negligence, the person did not knowingly gamble with another's safety, whereas in recklessness the person did. In cases of negligence, the person failed to foresee possible potential dangers. Criminal law. Criminal law is a branch of law that deals with crimes and punishments of those who commit them. It protects society from harms and punishes those who break the law. A crime is an act or omission that's prohibited by law and that's punishable by the state. There are two main types of crimes: misdemeanors and felonies. Misdemeanors are less severe crimes, while felonies are more severe crimes. The elements of a crime are things that must be proven for someone to be convicted of the crime. These elements vary from crime to crime, but they typically include the following. 1. The act or omission. This is the physical act that the person committed or the omission that they failed to do. 2. The mens rea. This is the person's mental state at the time of the crime. It is the intent to commit the crime or the knowledge that the act or omission was wrong. 3. The causation. This is the link between the act or omission and the harm caused. If the prosecution can prove all of the elements of the crime beyond a reasonable doubt, then the person will be found guilty. The punishment for a crime depends on the severity of the crime. Fines, probation, or jail time can typically punish misdemeanors. Felonies are typically punished by more severe penalties, such as prison time, heavier fines, or even the death penalty. Criminal law is an essential part of our legal system. It helps protect society from harm and to punish those who break the law. It's also a complex and evolving area of law as it's constantly being updated to reflect the changing needs of society. Criminal law is based on the principle of legality, which means that no one can be punished for a crime not defined as a crime when it was committed. Criminal law is also based on the principle of fairness, which means everyone is entitled to a fair trial and that the prosecution must prove its case beyond a reasonable doubt. The government enforces criminal law, which means the police, prosecutors, and courts are all involved in investigating, prosecuting, and trying criminal cases. Substantive criminal law is the body of law that defines the crimes and punishments for those crimes. It is the what of criminal law. It is concerned with the definition of crimes, the elements of crimes, and the punishments of crimes. Substantive criminal law is distinct from procedural criminal law, which is the how of criminal law. Procedural criminal law concerns the rules and procedures governing criminal case investigations, prosecution, and adjudication. The primary sources of substantive criminal law are statutes, case law, and common law. Statutes are laws that are passed by legislatures. Judges develop case law through their decisions in court cases. The common law is the law developed through judges' decisions over time. Substantive criminal law is an essential part of the legal system. It helps define what's considered a crime and its punishments. It also helps to ensure that everyone is treated equally under the law. Criminal law has changed drastically over the years. For example, in medieval times, people were sometimes put on trial by ordeal, whereby they might be forced to walk on hot coals, hold a red-hot iron, or be submerged in water to prove their innocence, on a belief that God would intervene to protect the innocent. Our attitudes towards criminal justice have changed drastically since then. Today, a claim of innocence entitles one to a fair trial before an unbiased trier of fact based on evidence and rules, with everyone being treated fairly.